attention to the third case on this morning's docket. That is case number 110945, State of Kansas v. Bollinger.
Good morning, Your Honor. My name is Kurt Kearns. I'm out of Wichita, Kansas. Chief Justice Nuss, I'd request that I be allowed to reserve 5 minutes for rebuttal.
5 minutes is granted.
This is a felony murder case where the underlying felony is an aggravated arson. The state, when this court looks at the record, will utterly fail to prove or to offer really any evidence that the decedent in this aggravated arson had any interest whatsoever in the dwelling that was burned. And because the aggravated arson statute mandates that the state prove beyond a reasonable doubt that the decedent had what it says, any interest in the dwelling.
Now, wasn't the victim still married?
Yes.
The defendant? What about the inchoate spousal interest? That's an interest in real estate.
He actually purchased that home and had the home and owned the home.
It doesn't matter if you're married. You have an inchoate interest as a spouse. If he were to die, she would have a elective share.
And there was no evidence presented by the state of any kind of inchoate interest in the home whatsoever. It's not argued currently on appeal that there was any such inchoate interest.
Isn't that any interest?
No, because we believe that there's an exact statute on point that says that just the act of getting married does not divest a man who has purchased and owns his own home from that home. It's still his. There's a statute.
Well, it might be his, but it's also hers, isn't it? Does she have an interest in it?
Not according to the statute. The statute uses the word shall, and the statute uses the word soul. And shall and soul do not make wife an interest.
She has an order from the court of temporary orders, does she not? Which allows her the right to live there and to exclude her husband.
She had.
Is that not any interest?
It might have been, had that order ever been served, because we have to back up, Your Honor, and ask the court to consider notice. We have a great common law history that says a man has a right to his home. His home is his castle. We don't divest and start doling out interest to any other people without some kind of due process. Number one, notice, opportunity to be heard. That order was never served. It was never picked up.
It was so effective, though, wasn't it? It's an effective order. Those orders are effective upon.
It had not vested until service, just like a protection from stalking or a petition from stalking isn't in effect until it's served upon the person that says you can't come around. Just like a protection from abuse isn't in effect until that's served on the person and says, hey, you can't come around. This was a never served order. It was never, no notice was ever provided to Brent for him to know about it.
But I think there's a difference between being effective as against the defendant and being effective for the beneficiary of that. In other words, that order created an interest in the victim, even though it may not have been binding against the defendant, the portion that excluded him. But the portion that gave her the temporary custody, why wasn't that effective when the judge signed it?
Well, for two reasons. Number one, the language of the order itself had already expired. Under any reading of the record, she had already located a place. She had already put down a security deposit. She had already packed her belongings in the vehicle. So, and the order itself said, until you, quote, locate another place to live. She had already located it. She had already processed her things out. She had already told others she had the apartment. In fact, she had told my client she was moving out.
And you think that order was intended not to cover a period while she was still residing in the home? I mean, that the court contemplated that, as soon as you find an apartment, the Brent could move back in?
I don't think that an interest, that if we're going to hold somebody criminally responsible for a crime due to somebody else's interest, there needs to be some indication that that human being knew about that other person's interest or had some notice of
Where
that
does
other
that
person's
come in the
interest.
law? I mean, we have some of the cases are that, you know, someone is a managing agent of a property or something like that. There's no proof necessarily that a defendant knew about what that nature of that interest before the crime occurred.
Well, we also have a case law from this court that talks about what is any interest and what qualifies as any interest. And what we have are some cases, the Boone case, for example, that says a leasehold is any interest. We have Crosby and Heck case from this court that says a mortgagor, the bank, doesn't have any interest, even though they claim there's an interest. The insurance company doesn't have any interest. So the question really becomes, what is any interest? And our position is that you can't simply say, by the act of getting married, a magical intellectual exercise or transition took place that made that act of marriage, gave her an interest that she otherwise didn't have, just by the act of getting married.
Well, I'm going to pile on this in a different way. There had been divorce proceedings filed, correct?
Yes.
And so, I mean, my first thought when I was reading this and went back and looked, you know, KSA 232801 says that once there's a filing, all property owned by married persons shall become marital property. So if you're going to look at the statutes, by operation of law, she's got an interest.
Only if she owned it.
Until the district court divvies up the property, all of the married property, or all the property owned by either one of them falls under the jurisdiction of the court. And so it seems to me that statute goes directly against what you're arguing.
Well, only if you take the leap and say that she owned the house, because what it says is all of the property, and it also, the statute that we talked about in our brief talks about jointly acquired property being held. In the Katie case, it had to be jointly acquired after the divorce is filed for her to get an interest, not something that he owned. The distinction here is he owned the house, bought the house, and it was his prior to the marriage.
I disagree with that. It seems to me that the statute on giving district courts the authority to divvy up property once a divorce is filed says once this action gets filed, doesn't matter who owns it, doesn't matter anything, the court gets jurisdiction over the whole pot, and each married person has an interest in it until the court decides otherwise. And that's the place you were in. So I guess I'm trying to figure out why 232801 doesn't stop this argument in its tracks.
That statute doesn't stop this argument in its tracks because what we have here is an individual who allegedly burned down his own home. He burned it down before he was served with any kind of court order that says this is joint property. You can't do with it what you will without any notice to him whatsoever. So that's the primary distinction that we're making here is, had he been served with it, had he been on notice of it, that she had an interest, but the overwhelming majority of the evidence here was she didn't think she had an interest. He didn't think she had an interest. The court order went unserved. He had no notice of it. So the issue becomes, do we now hold a citizen criminally liable for an interest that he knew nothing about?
Do you have any case law that supports the notion that an element of this is notice?
Well, I would say due process. Before you start divesting
Is there any
somebody
any
of...
case that says...
No, there's no case
Okay.
that says, as to, quote, any interest, that interest has to give notice. But I would respectfully submit that if we're going to start dealing out interests in property, due process requires that we give some kind of notice before, especially to make somebody criminally responsible for acting against another person's interest. They certainly should have to know about it.
Essential for the culpable mental state?
Yes. And the argument kind of dovetails right into the vagueness issue, because what is any interest? This court has had struggled for years now over what is any interest. What we do know is a leasehold is good enough, a mortgage order is not good enough, an insurance person is not enough, in a situation where a man owns his own home, marries, and by statute, has a statute that says that shall remain his sole property, and this court's been very clear what shall means. Shall means shall. Meaning his sole property, sole means sole, that when we have that particular language, that's the distinction we have here. We don't have people that married, bought a home together, and then had this situation.
Typically,
To
no, go ahead,
I was
Judge.
gonna say, to follow up on your line of reasoning, it would appear that you would say, at any point in the marriage, this marriage, the husband could have said to the wife, "This is my property. You have no right to be here. You must leave. And if you don't leave, I will file a legal action to evict you." Is that your position?
My position is that same husband could say, you know what, this is my house, everybody out, and assuming there's no damage to any other property, there's a Supreme Court case I've cited in the brief that says he can torch it. It's his. He can do with it what he wants. Now, they can charge him with burning down wife's clothes, which they didn't do, or burning wife's property, which they didn't do, but that dwelling is his. He can say, everybody out, it's got rats, it's got mice, it's got lice, I'm torching it, it's mine. And the law says that's his right.
So for no reason whatsoever, he has the right to tell his wife that you must leave. You have no interest in this property because my name is on the deed.
Because
Is that your position?
That's my position.
Can he sell it?
Yes.
He can sell it by himself without his spouse's signature?
Well, the statute says it shall remain solely his, so
Well, I'm talking as a practical matter. As an attorney, would you ever advise a client to take deed to property of a married husband without the spouse's signature?
well, as an abundance of caution, probably not. But did the state prove beyond any reasonable doubt that she had an interest under these particular facts? And respectfully, our position is no.
Justice Rosen, do you still have a question?
I was just going to add on to the any interest, but I won't do that at this point. But on issue 4, which is the out-of-court statements, I just want to go through my understanding of the sequence of that. There were, I believe, 3 witnesses that offered out-of-court statements. And the way, or hearsays, what you say are hearsay statements. The way that happened was prior to trial, the state filed notice that they were going to seek introduction of, quote, out-of-court statements. And then there was some short hearing on that, and it was determined, we'll deal with that if there's a motion in limine filed regarding those statements. That never occurred, as I understand. Are you with me so far? Is that
Yes,
right?
Your Honor.
And then at trial, witnesses were called to testify, and one was a Julie Norris who testified about 3 of those out-of-court statements, and the only objection was after she testified, Judge, I want you to note my continuing objection, and the court said noted. And that's the only objection to any of this at trial? That's correct.
You read the record correctly?
That's how I read the record.
That's what the record is.
Okay, so there was really no opportunity as this evidence was coming in to specify what's the problem with this testimony. It was never contemporaneously objected to until after the testimony was given. And even then, it wasn't very clear as to what out-of-court statements there was an objection to. That's how I see it.
Other than it's clear from the record that this trial lawyer that tried the case, and I wasn't him, but at least there was an understanding that he had a continuing objection to those hearsay statements because the judge
question
said
is
noted.
to what?
Yeah, I'm with.
Okay.
And as I stand here, I wish the record would be clear on that point.
Okay, thank you.
Counsel, did you need 30 seconds to wrap up, or you think you've made your points and you'll finish up on rebuttal?
I'll finish up on rebuttal, Your Honor.
Very good. Do we have any more questions? All right, thank you, counsel.
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers. If indeed Bollinger has the right to keep his wife out of his house, despite her being the wife, then at that point she has a lease and we're good under Boone. She was able to stay there. He hadn't tried to evict her yet. She has a leasehold interest that this court has clearly declared is sufficient for the any interest in the arson statute. I admit that my understanding of property law is clearly not as good as some of yours, especially since I've never heard the term incoherent spousal interest. So I would like to add that to my brief to the extent that you're willing to consider it. I'd like to briefly talk about, if there are no further questions on that, the misconduct.
Did I have my understanding of, on issue 4, the out-of-court statements? That's basically the sequence. The only objection was offered after
Julie Norris.
Julie Norris's testimony, and then that was supposed to also attach on to the other 2 that subsequently testified.
Yes.
And there was never any
Timely or specific objection?
to any of it.
Correct.
Okay, thank you. Go ahead.
The state would encourage this tape or court to listen to the tape at high volume and decide for themselves if they can hear the statement that the prosecutor said that she could hear, but in no way was there misconduct from her reasonable inference from the evidence. I myself listened to the tape. I can hear something that sounds like, please help me, and then you can hear the noise after. I can't see how any of this is misconduct. The hearsay wasn't preserved. I don't think the statute is vague, and clearly Brenna had an interest in her own home, which she was living and residing, and happened to be alive at the time that he set a fire that killed her. There are no further questions.
Any interest is rather broad. I mean, if I, as a neighbor, had a certain attachment to the property next door, I thought it was beautiful and aesthetic, would I have an interest if my neighbor burned it down?
No. I do think historically it's been tied to property. And here, Mr. Bollinger is stuck with the facts of his case. He's not allowed to raise hypotheticals that don't fit him. But no, first of all, most officers and prosecutors, myself included, are not property law experts. They have always, I think, gone on the basic, they're husband and wife, so clearly they have an interest. I can't see us ever pushing the statute to the bounds, but absolutely no, just I think it's nice is not a sufficient interest under law.
Anything to add to your argument that the statute is not vague?
It says any interest, it means any property interest, and no, I don't think I have anything to add that's not already in the brief. Other than this court is, well, no.
Other than inchoate interest.
Right, but that's to the sufficiency of the evidence, right?
Any further presentation?
No, Your Honor, unless there's further questions.
More questions? Thank you, counsel.
Thank you.
We reserve 5 minutes for both.
May it please the court. Your Honor, the state's argument that's kind of developed on appeal as well, the court ought to look back onto these facts and out of these facts pull out a lease. Now, the distinguishing part of this is in the Boone case, the defense said, yeah, there is a lease. There was testimony that there was a lease, and the court pointed that out when in affirming that the leasehold interest is any interest. What we have here is nothing. We have, she lived in the house, she was married.
Well, that's the point I was going to make. Even as Justice Biles pointed out, this case is subject, or their situation was subject to 23-2801. There's been a filing of a divorce, and certainly under most, at least marital division of asset or property, is that even if property is owned prior to the marriage, you're entitled to the appreciation during the time of the marriage. That becomes an interest that the court considers, and that's done in almost every divorce case where there's property that's owned that people bring into the marriage. Once you're married, you're entitled to increased value of that property. And so why isn't that an interest?
Well, because when you're talking about interests that are being imposed on a man's home, we're talking about, well, first off, had it vested? Yeah. And the answer to that is, how could it vest before she even picked it up? How could it vest before he was served with it and knew what it said? I mean, for all he knows, it says this, just like the statute. For all he knew, it says what the statute says. This is still my house. She's moving out. Well, she's got a place to stay, and she can stay here until she finds another place. She's done that. Boom, it's done. But because of the window of when this happened, we have to look at what interests were in existence at the time of this fire.
Do you have a position on whether or not this was marital property pursuant to 232801?
Our position is that it isn't, and our position is
And
that
why
there's-
not?
Well, because of the statute that talks about how he brought, and I can get the exact statute, I don't have it memorized because I don't do domestic law, but it's briefed in my brief. It talks about how his house that he purchased prior to the marriage is solely his and remains solely his.
I understand, but the statute with respect to the filing of the divorce says all the property that's owned becomes marital property.
Once it's served, I would agree.
Okay, so
Because once
that's
he
what I'm
has
driving
notice,
at.
Once
If
he says, oh, I got some notice that if I burn this down now, I'm in trouble.
Your
I'm not
argument
saying he
is-
did, but we're saying that without that notice, that's still his house. He can burn it
So
down
it
if he wants
doesn't,
to.
it doesn't become marital property until the parties are notified. That's your argument.
And due process mandates that we don't divest someone of their house by granting other people's interest in it without some notice and opportunity to be heard. He didn't have notice. He didn't have notice at the time of the fire, that's undisputed. I want to focus a little bit on this whole, that it dovetails right in with the vague nature of any interest, because nobody really knows what it is. It's one of these, we kind of know it when we see it, and but we're not really sure. What is any interest? And we've struggled with that over time. The mother-in-law who moves in, well, am I in the same, would he be in the same situation if mother-in-law lived upstairs? She's got an interest. The children, well, I might get this house when you die. I got an interest in it now. My girlfriend who moves in and takes over a closet and a drawer. Oh, sorry, now she's got an interest as well. The issue is, what kind of notice do we give citizens in the state of Kansas that say, when you read this statute, you're on notice that you can't do certain things, or it's a violation of the law? Well, anybody with any interest, okay, well, what is that? It wasn't defined for the jury here. We have to struggle and go to the Supreme Court of Kansas to figure out what it is, not once, not twice, but at least 3 times prior to today. So, and our Supreme Court has even gone both ways. Well, this, a leasehold is, this isn't. This is, this isn't. So when we're talking about statutory construction, this court's also said misconduct. There was a statute that prohibited police or officer misconduct. And this court said, wait a minute, misconduct, that's vague and it's ambiguous. I mean, what is misconduct? Well, how is any interest any more specific than misconduct? As to the prosecutorial misconduct, what we have is interpretations of evidence. You can go ahead and listen to the tape, but what they're describing it as a scream without any evidence that there ever was a scream. What they're doing is attributing a scream to an alleged victim without any evidence that that scream was an alleged victim. What they're doing is then saying, so they're adding to the evidence in the course of closing argument, which also, by the way, creates sympathy. Oh, look at the suffering. She's now screaming, saying, quote, help me. No, that's the jury's call. If you're going to rely on the tape, let the tape be the evidence. But to tell them, oh, doesn't it sound like this?
And then they qualified, it's up for you to decide.
Right. But if I tell you what a transcript says, before you, that's why we have laws that say the transcript doesn't rule. We have, I know, especially in federal court, we say, no, the tape recording rules. Because if you give them the transcript, they start hearing what's in the transcript as opposed to what's actually on the tape. So to be interpreting that tape in closing argument without any evidence, we believe is problematic. So we would ask that the court grant Brent a new trial with regard to both the vagueness of that, any interest, how was he put on notice of that anybody might have any interest, and secondly, the state's failure, frankly, to prove. They're going to talk about an appeal that what they've proved, but did they prove that there's a law with an incoherent interest? Ladies and gentlemen of the jury, look at this statute.
Was the constitutional argument raised below at all at the district court?
The vagueness?
Yes.
No. It wasn't raised below, but we briefed, there's at least 2 reasons why this court can hear it on appeal, one of them being it's a constitutional issue, and we're not getting any secret or nasty advantage by having it raised now as opposed to lower. I frankly wish you would have raised it lower. Thank you, Your Honors.
Any further questions?
Just one. Is 59, KSA 59505, is that no longer law? Or do you know? That's the probate provision that says the surviving spouse shall be entitled to receive 1/2 of all real estate of which the decedent at any time during the marriage was seized or possessed.
I think that, as far as I know, that statute is still in play.
Okay.
What I also know is there was no evidence that that statute existed, the jury wasn't instructed on it, and so they would have to guess on what. Is it that interest we're talking about? Is this incohate thing we're talking about? The issue is, what evidence did the state put on? And here, it was zero. She lived there, he was the wife. That was it. Thank you, Your Honors.
Any more questions? All right, thank you, counsel. We thank you both for the arguments this morning. Court will take this matter under advisement. Now